In this post, we are going to analyze the proposed amendment to the Constitution in detail and see what it means. As we mentioned in our earlier videos, the first line is not only recognizing Aboriginal people as the first people of Australia, but it is stating that they should have a voice because they are the first people of Australia. The first sentence of the amendment is not a separate clause, it is one sentence that is then finished with the following clauses. Therefore, according to this text, the reason for the voice is not the gap or disadvantages that Aboriginal people may have, but they must have a political advantage because they were here first. Besides being racist and insulting, the authors of the text have been so ignorant that they don't even know that all Aboriginal people are not one nation. They are different people with different cultures and languages. Their settlement happened over many waves that were thousands of years apart. So according to the government, the cut-off point for deserving a political advantage was 1788, and anyone arriving here after that is some kind of second-class citizen. Clause 1. This clause introduces a separate entity alongside the judiciary, executive and legislature called the voice. While we already have a racially discriminatory constitution in a modern society, in the spirit of entrenching equality and human rights, we must remove all references to race, not going the opposite way, and further entrench racial division in the political and governance system of Australia. The sovereignty of land derives from all peoples of this nation, all people that call Australia home, not based on their date of arrival. This amendment will change the system of government whereby Indigenous peoples will have a second method of influencing public policy and the ability to have an additional say on every law and administration. This will erode equality of citizenship where everyone should be equal not just before the law, but also before those who make the law. The main point to note here is that, as this is going to be entrenched in the Constitution, it would be permanent. Mechanisms or laws to improve standards should be temporary and terminated when goals, like in this case closing the gap, have been achieved. Along with our first comment, this further emphasizes that the reason for this voice is not closing the gap. Clause 2. Make representations to Parliament and the Executive on matters relating to Aboriginal peoples. The scope is not limited to matters that relate only to Indigenous people. The only limit on the scope of the subject matter is that it must relate to Aboriginal people. As they are citizens of Australia, it is not possible to imagine an issue that does not relate to Aboriginal people. Please note, the High Court and not the Parliament will have the final say on the scope of the subject matter of representations. When a new legal document is being written, it should be as clear as possible. We should be able to understand what the voice can and cannot do now, before voting for it, and before adding it to the Constitution. There are so many unknowns about what flows from representations. It should not be left for the High Court to fill in the gaps. Such uncertainty could be removed if the voice was legislated and not put in Constitution. In that way, the Parliament could amend the law if they needed to, without the involvement of the High Court. The inclusion of the executive government means that the scope of their representation expands to legislations passed years ago. The policies, the operations of the public service, and so on, at all government levels, ranging from parking tickets issued by local governments all the way to multinational projects such as submarines managed by the federal government. Clause 3 gives Parliament, subject to the Constitution, the power to make laws relating to voice. While this clause states that the power and scope of the voice can be legislated by the Parliament legislation would be subject to High Court interpretation. Therefore, Parliament is not totally free in shaping the voice the way that they intend to, but they are restricted by the issues mentioned before. This is why Mark Dreyfus, the Attorney General, had suggested adding a phrase to this clause to give the Parliament the power to determine the legal consequences of representation. This would have allowed the government to control the power of the voice from being extended to areas such as foreign affairs or national security. But this idea was rejected by the referendum working group. Here is the proposed constitutional amendment that by design is vague. As it is clear from the comments by developers of this amendment such as Marsha Langton, Megan Davis, and Tom Mayo, it is deliberately written in a way to be able to force its decisions on the government. As Marsha Langton says, to make sure that it is not a toothless tiger.